All rise. The Court of Appeals First Appellate District of Ohio, with the Honorable Beth Myers, is now in session. Please be seated.
Good morning, everybody. Welcome to the First District Court of Appeals. We have two cases on for argument this morning. I see only one counsel at the table. Thank you very much. The first case to be argued this morning is in Re J.N. And counsel, if you'll introduce yourself for the record on who's going to be arguing, and introduce also your co-counsel.
Yes, Your Honor. Jessica Moss, I will be arguing. Co-counsel is Corinne Hill.
Good morning.
Mary Steer from the state.
Ms. Moss, if you want to step up, you will have 15 minutes to argue. Would you like to reserve any of that time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes.
All right, I will keep your time, and whenever you're ready, you may begin.
Thank you, Your Honor. May it please the Court. My name is Jessica Moss, and I represent the appellant J.N. in this case. I'm going to focus primarily on the first and the fourth assignments of error. This case is about an end-of-disposition hearing pursuant to 2152.84, as well as what happened after disposition when there was a change to the terms of J.N.'s disposition. As to the first assignment of error, there are two reasons why it was an abuse of discretion. The first was all of the evidence and the reports presented at the end of disposition hearing showed that J.N. had been rehabilitated.
Ms. Moss, may I interrupt you very rudely? I am so sorry, but I realized I forgot to announce to the participants today why we have an empty seat here. And I am so sorry to interrupt your argument to do this, but I think it's important that I put that on the record. Judge Winkler had a family emergency this morning. He is going to participate with us. He will be a part of the panel. He is going to watch the oral arguments and will participate in every other way, but could not be here this morning. And again, I am so sorry. I'm going to add 2 minutes to your time and allow you to pick up where you left off.
Not a problem, Your Honor.
Thank you.
So J.N. had changed his behavior. He was complying with the rules. The JFS worker, Furman Williams, indicated that this behavior of J.N. was typical of other youth. Additionally, what behaviors he was exhibiting was exacerbated by the time that he was at the Youth Development Center, which was unusual, since usually youth are there for a much shorter period of time. Both JFS, the probation officer, and Youth Development Center said he was complying with the rules.
So the violence that he displayed they said was typical of a teenager?
So at the actual end of disposition hearing, the caseworker who wrote the report that the court relied on, which went into one of the other assignments of error, that was not presented to the court. The caseworker had the opportunity to provide that information. The caseworker did not provide the information. While the caseworker talked about several issues that had occurred, said that J.N. had been making changes to improve his behavior. And so both he and the probation officer and YDC were all happy with his change in the behavior.
So the information of him choking another resident you're saying was not presented?
Correct. So if the state wanted to introduce that information, the state certainly could have. They chose not to. The worker who wrote the report was the one that was there. And that was the concern with the fact that this report that was presented, while it occurred under the same case number, was not part of the actual delinquency case. So J.N.'s trial attorney was not part of those proceedings. Those occur in front of a separate magistrate, which is one of the dependency magistrates. So essentially, those are separate proceedings and not the same proceeding. And that's why the court erred in relying on that information.
Okay, you're saying the court erred on relying on the information because the court just should have shielded its eyes and not looked at this report, right? That was in the record?
The court is not supposed to take judicial notice of things outside the record, and this effectively was by a different magistrate outside of the record, solely because it occurs under the same case number because of how these cases occur in Hamilton County. But if this information was going to be presented to the court, it should have happened at the end of disposition hearing, and it did not, and that did not happen. The only information that was presented was how well J.N. had been doing, and while there were some hiccups, that those were not serious, and everybody was happy with his progress. And the report from the court's report from Dr. Dreyer indicated that JN went from a moderate risk to low risk and was at the lowest possible risk to reoffend. He had utilized the skills he learned in treatment. He was able to understand how he could avoid his triggers. And the public interest and safety was not served by continuing his classification, which goes into the research that Dr. Dreyer indicated in her report, showing that juveniles pose a low risk to reoffend, especially those that have done treatment pose a low risk to reoffend, and that's different from adults. Additionally, the court erred in saying that JN put blame on the victim because, again, that was not shown by the report from Dr. Dreyer in JN's own report or letter to the court, as well as what he completed in treatment. Additionally, in Dr. Dreyer's report, she indicated that he did not have any of the risk factors for a lack of empathy or remorse. So the court indicating that it was not going to terminate his classification because he was not remorseful contradicts the evidence and testimony that was presented at the hearing. Additionally, he was growing and maturing, and that's what YDC had said, that he increased his self-control. And the research says that kids grow and mature out of this kind of behavior. He was able to understand how he could avoid his triggers, and he was able to change his thought process and his cognitive distortions. The second reason that this decision not to terminate JN's classification, the fact that it was arbitrary and unreasonable, is the fact that 1 month after making this decision, the court initially said that he was not matured, that he hadn't changed his behavior, he was not remorseful, and a month later terminated him from reporting probation and put him on non-reporting probation, saying that he had abided by the terms of probation, therefore that he was mature enough not to need the supervision of probation.
Well, wouldn't it make sense that if the court determined that his sex offender classification should be continued, then maybe it wasn't necessary to also have him on probation? I mean, there was going to be some sort of monitoring there, right?
Well, the basis that the court made the decision to move him from reporting probation to non-reporting probation was that he had complied with the rules. So to say he cannot be, his classification should not be terminated because he has not complied with the rules, turn around and say that he has complied with the rules, those two would be mutually exclusive.
So the court was saying he had complied with the rules of probation?
Correct.
Okay.
So if there was any failure to follow the rules, then if the court is making that decision to terminate his probation, they are looking at the fact that he did successfully complete YDC, he followed through with what probation was asking, and that's why probation initiated the end of disposition for him, because he had done all of those things. So the things that showed that his probation should be, reporting probation should be terminated were the same reasons why the court should have upheld or should have decided not to continue his classification. As to the fourth assignment of error, the juvenile court's decision to change him from reporting probation and place him on non-reporting probation monitor time was not valid and exceeded the jurisdiction of the court and violated due process. Now, the state cites to the RB decision, but RB is distinguishable from this case. The difference between JN and RB is that in RB, the end of disposition hearing had not happened yet, whereas in JN, the court held the end of disposition hearing. The state, probation, and defense all agreed that this was the appropriate time to have the end of disposition hearing. And at the end of disposition hearing, the probation officer said that the plan for probation was to terminate JN from probation. It was not to modify the probation to non-reporting probation with monitored time.
So you're not arguing that we need to overrule RB. You're suggesting it's distinguishable.
It is distinguishable.
So everybody went into this hearing with the idea that probation was going to be terminated, and that was going to be that. That
Correct.
There was no notice or indication that monitor time was a possibility.
Correct.
Is what you're saying.
Yes.
Okay.
And so that's what makes this significantly different from RB is the fact that everybody was under the assumption that monitoring time wasn't even on the table, that probation was going to be terminated, and that's why the disposition had ended.
Why was the end of disposition hearing held so early?
The end of disposition hearing was held so at the time it was because the probation officer thought that JN had completed his treatment and was planning to terminate him from probation. So at that point, his disposition was ending, and that's why the court held the end of disposition hearing.
Okay.
In regard to the order for monitored time, order to obey the law is not a de facto order for monitored time. And the reason for this is because when a child is placed on community control, the statute requires the court also order the child to obey the law. But the order to obey the law is only for the period of time that the orders of community control are in place. Otherwise, that makes the statute redundant by making a separate order of obeying the law. A suspended commitment is not a standalone disposition. Again, it is meant only for the period that community control provisions are in place. Here, the non-reporting probation, the court lacked jurisdiction to impose monitored time. JN had completed treatment, the court held an end of disposition hearing. Therefore, J had finished all of his community control orders. And once probation ended, the court's ability to make any further disposition also ended. At that point, this becomes a final appeal order once the court enters the dispositional order. If the court wanted to invoke any kind of continuing jurisdiction, the court was required to comply with Juvenile Rule 35. But there was no motion or request to invoke jurisdiction prior to the time that this order to place JN on non-reporting probation with monitored time occurred. Additionally, this violated fundamental fairness and due process. There was no notice, there was no hearing. There was no ability for JN to be able to challenge the fact that this monitored time would continue until he's 21.
Is that typically the way it works? That there's a heads up and so the court will say, hey, look, I know that you're trying to terminate probation. I'm considering continuing the child on monitored time. We're going to set a hearing so that you can make your arguments. I mean, is that typically the way it works?
Generally, no, and that is what one of the problems is. But this is also different in Hamilton County than what is occurring across all the districts in Ohio. In other districts, you have courts that are imposing, at the time of the initial disposition, a specific period of monitored time. And that does not happen in Hamilton County, at least in any of the appellate cases that have come out of the first district.
So Hamilton County, the judges in Hamilton County just impose monitored time without any notice or a hearing, is what you're saying?
That's correct. That's how it has effectively been working. Okay. And so instead of tailoring a disposition specific to a juvenile, all juveniles in Hamilton County, essentially, if they're charged with a felony, are going to be on reporting probation or non-reporting probation monitored time until they're 21, when that isn't necessarily what is the most appropriate dispositional penalty for them. Here, additionally,
You have about 1 minute left. I did give you the additional 2, but you've got about 1 minute left if you want to reserve your time.
Additionally, Juvenile Rule 34 allows modification of temporary orders by filing a motion to the court and the court holding a hearing. And that, again, is the procedure that should have occurred, but did not occur in JN's case. If there are no other questions right now, then I'll reserve the remainder of my time.
All right. Thank you, Ms. Moss. Ms. Steer? You have 15 minutes to argue.
Good morning, Your Honor. Counsel, may it please the court. If I could just pick up with RB, and I think the problem is even though other districts may do it differently, here in Hamilton County, the defendants are still held. Their disposition continues until the age of 21, and that's what happened here. JN is still under jurisdiction of the juvenile court until the age of 21, and that's what RB held. That doesn't functionally change anything. The court maintains jurisdiction. Although RB was a different situation where they were trying to figure out, I think in RB it was a question of whether or not the end of disposition hearing had happened in time enough after he had been, after the end of his disposition. The court concluded that he still had, the juvenile court still had jurisdiction because there was still monitored time.
Did the state try and stop this hearing and say, for example, hey, wait a minute, we're having this hearing too early. He's not at the end of his disposition yet.
The state didn't, as far as I could see in as far as I could see in the transcript, the state didn't. I'm not
Is
sure.
that a waiver of any argument that the timing
I don't-
was off?
I don't think that it is, Judge, and because I think that what happened, it's a strange procedural posture because they had this hearing, he was 16, so there were still 5 more years that he was going to be within the juvenile court's jurisdiction just based on the initial disposition. I'm not sure why they had it so early, but I do know that at the end of that hearing, what did happen, the only thing that happened was he was continued as a Tier 1 registrant. There was nothing that ended, there was no talk of ending the disposition. Nothing terminated at that time.
Will they have to have another hearing then when he reaches the end of his time?
I think that they would because when I was calculating the time, I think that, he's not going to be, he turns 21, I think, in 2025, I think, if I did my math right.
So what's the purpose of even having this hearing? And is it a nullity? I don't want to say a nullity, that has some legal connotations, but
Right.
If I accept your argument that, hey, he's not at the end of his disposition, what do we do with that?
That's what, and that's why I argued that it wasn't a final order, because I think that it was premature. I understand that special proceedings where substantial right is affected are final orders, and I do agree that this is a substantial right as far as your registration status, but I'm not sure that, I think the word affected is the problem, because I'm not sure that he was affected really in any way. All it did was continue what he had already applying to him, which was the Tier 1 registration. At the very least, under 215285, he has the ability 3 years after that, the entry continuing his Tier 1 status, he can ask again to have it lowered.
So if the hearing had not occurred, he would have just continued on the tier status unabated until he got to the end of his disposition?
That's my understanding, Your Honor. And I believe that what could have happened was the probation officer could have said, okay, he's completed treatment, so we want to terminate his terms of probation, which I think the court clearly could have done, and I think the court could have ended everything completely or done what it did in this case and continued him on non-reporting monitored time.
I thought that's why they wanted to do this early, was for the purpose of terminating him from probation.
That may have been, but it didn't happen. There's no
Right.
order that says that his probation is terminated.
Was it, I mean, I haven't read the transcript yet of what happened at that hearing, but was that what was discussed at the hearing? Was
Really-
to terminate probation?
My understanding from the transcript is all that happened was talking about whether or not he should be a sex offender, whether or not he should be
It
registered.
was simply about continuing the Tier 1
Correct.
registration, not
Correct.
about, but I mean, there was testimony about him having completed what he needed to do with probation and everything like that, right?
Yes, and I think that all goes to when you're looking at the factors in 215284, and then they go back to 215283. I think that all of that was in terms of those factors, and so looking at whether or not the status should change. At least that's how I read the transcript. And when you read the juvenile court's entry regarding that hearing, the end of disposition hearing, everything is kind of pegged to those factors. And everything that happened in the hearing went to those factors.
Okay.
And I think that kind of goes back to the first assignment of error, because I don't think that, I don't know how you can say it was an abuse of discretion. Clearly, the court looks at all of the information, but just because the experts say one thing, the court obviously is not bound by that. It's not just, the court's not a rubber stamp, and the court looked at other factors. And if you look at, I think, on the second assignment of error with respect to the progress report from the dependency, that was part of the record. So in Ms. Moss's brief, she cites the In Re JC. That's a different situation. In that case, the court looked beyond the record. I think the court looked at its own files. This was filed in this case. It was trial document 142. And in this case, the dependency and the delinquency were kind of inextricably wound, because part of the problem was when he was in, my understanding is when he was in the residential care, part of the problem was they had nowhere to put him, because for him to go to his father's house, there were children there and they were concerned about that. So I think that they were all wrapped up together. And I don't think that the court went beyond the record, because that's in front of this court now too. It is part of the record. It's part of that document. And I think that that was just another factor that the trial court could consider, in addition to the expert reports and his past. He did have 2 probation violations. His probation officer said that, he kind of had a tendency to leave, and so there was still some kind of hedging even during the January 14th hearing about his behavior while he was at the residential care. So I would argue, first of all, I'm not sure that this is a final order, because I'm not sure exactly how it affected what he had. It just continued what he had. And to the extent that it was a final order, I think that the court did not abuse its discretion in continuing him on the Tier 1. He's really not prejudiced by it, because it's just keeping him where he was going to be anyway till the end of disposition. And with respect to the 4th assignment of error, the court continuing him, or the court terminating reporting probation, changing it to non-reporting probation, monitored time, I think that under RB, that really doesn't affect anything substantively. It just continues it. It did, to the way that it did change things for him, it actually benefited him. He can't really say that he's prejudiced by it. And I think that under Rule 34, as I read it, while the court has to have a hearing if another party asks to change the terms, I think if the court itself wants to change an order, a disposition order, it just has to give notice. That's at least how I read it. It's the last line.
That's the problem, though, in this case, is there wasn't notice. There was no heads up given to him that, hey, you might be continued on monitor time. Because what it sounds to me like what his lawyer was doing was going to argue, take him off probation completely. And if there would have been a heads up, hey, monitor time is a possibility, then there would have been some sort of argument about why he shouldn't be placed on monitor time. They didn't have that opportunity here.
I think that that's probably a better practice. I just don't think that that's how it happens in Hamilton County for whatever reason. I think that.
But is it a due process violation to do it
I'm
that
not
way?
sure that it is a due process violation, because I think that when you look at RB, I think the court already determined that and said that there was not, because they were not adversely affected, because it really didn't change what had already occurred in the initial disposition. And I think unless you're going to overrule RB or somehow change RB, I think that would apply to the 4th assignment of error as well. So the state would ask that it's affirmed. I think it would just keep everything as it is for JN for now until he either ages out or they actually do terminate his disposition officially. And then, I suppose that they would have to have another end of disposition hearing. I guess it would probably be to his benefit, because I'm assuming if he's still progressing, maybe it would be a better result for him. Thank you.
Thank you. Ms. Moss, you have 3 minutes remaining. And if you would, will you start by addressing the issue of whether there is a final appealable order, and what happens? Is there another end of disposition hearing required when he reaches 21, or probation's terminated?
Yes, Your Honor. So yes, this is a final appealable order, and this court has addressed 2 other cases where the end of disposition hearing occurred, although in those cases the order of non-reporting probation with monitor time continued out, and that issue wasn't raised in those cases, but the end of disposition hearing was a final appealable order in those cases, and that's in In Re DR and In Re KB.
And is it your position that there'll need to be another end of disposition hearing when he reaches 21 or probation's terminated?
No, this should be the end of disposition hearing again, all parties agree that this was the end of disposition hearing, and if the state wanted to challenge that, the time for them to do that was at the hearing. JN relied on that in having this hearing. But additionally, the statute does not say that the end of disposition hearing must occur only when a child turns 21. Now, the case in RB was that is what ended up happening, but that's not what happens in every case. Not every juvenile completes disposition at the time that they turn 21. Just as in JN's case, his disposition was complete, and that's why the court held the end of disposition hearing. And on page 10 of the transcripts, the probation officer specifically said, my intention is to terminate JN from probation.
So then he would be out of the juvenile court's monitoring. I mean, he would have the tier 1 registration requirement only, is what you're saying the goal was with that hearing. Terminate him off of probation, and the only thing that he would have left is the registration?
So the end of disposition hearing is supposed to be on or about the time that the child's disposition ends. And so whether or not what happens after, in this case, the terminating his reporting probation isn't what the court is supposed to look at the .84 hearing. The plan is that's the time that the disposition ends. So the fact that the probation officer right after that was going to terminate probation, that follows with what the plan is and what the statute intends for.
But if that's not what happens, and it's not at or near the time of the end of disposition, do we have a final order? And isn't your client going to want an end of disposition hearing to make the arguments that he makes, in this case, in a few years?
Jan's position is that this was his end of disposition hearing. And
doesn't he want another one if he can establish that he shouldn't be continued on registration?
So in this case, and what the statute says, at the end of disposition hearing, if the classification is continued, then at the .85 hearing, that would be the next opportunity to make some change. In this case, the problem is that if this court were to not find this to be a final appealable order, then JN would be in a situation where the probation officer is saying that he wants to terminate him from probation, and the court took this other step outside of the knowledge, notice, or the ability to challenge that, where JN didn't have this ability.
That's a different issue, though, isn't it? Whether he had the ability to challenge it and whether it's a final order.
I think that they go hand in hand. JN did have a right to have finality in his initial disposition if there was no modification, which includes hearing, notice, the opportunity to challenge that. That did not occur. Additionally, JN has a right to have an end of disposition hearing at the time that his disposition ended, which is exactly what happened in the other two cases, in In re DR and In re KB, where the end of disposition happened before either of those juveniles turned 21.
You have about 1 minute remaining.
We would ask that this court reverse the juvenile court's decision, continuing JN's classification, and vacate the juvenile court's decision, continuing JN's suspended commitment to the Department of Youth Services.
Thank you. Thank you very much. Counsel, thank you both for your arguments this morning. We will take the case under submission and give you a timely written opinion. The next case on our docket this morning is State of Ohio versus Embry.
Your Honor, just as a housekeeping matter, Mr. Embry, my client, is here this morning. Is it okay if he sits on our table, or would you have him remain in the audience?
I think I'd rather have him remain in the audience. That's usually our procedure here. Thank you. And counsel, if you'll both introduce yourself for the record this morning.
Paula Adams on behalf of the State of Ohio.
Joe Ocello on behalf of Mr. Embry.
Mr. Ocello, you will have 15 minutes to argue this morning. Would you like to reserve any of that time?
Just 3 minutes, please, Your Honor. Thank you.
All right. And whenever you're ready, I will keep your time for you.
Thank you, Your Honor. Your Honor, factually speaking, may it please the court, with regard to Mr. Embry, factually speaking, this case was fairly simple and straightforward. This is a traffic, it started out as an investigation, turned into a criminal matter. Ultimately, Mr. Embry was convicted of carrying a concealed weapon. as the court, I'm sure, is plenty aware, what the carry and concealed weapon statute states, the potential for an affirmative defense, we think this boils down to two very simple issues. The first of those issues is whether or not this was ready at hand. We addressed that in our brief to the court, but more interestingly, what I wanted to point out is that in the state's response, they rely on a case, State v. Davis. I also relied upon that in some of my briefing to the court regarding this issue. And the reason I think that's important is because the state relies upon State v. Davis, indicating that, first and foremost, apologize for the language here, and that State v. Davis, that the fact that Mr. Embry had this weapon and it was ready at hand and in the front seat of his vehicle. But I think the important thing to take away is that the factual distinction between this case and Mr. Embry's situation. And the very key distinction to take away is the fact that in State v. Davis, there was a magazine, and it's specifically cited. The facts are fairly analogous. Mr. Davis and his situation was 6 hours removed from being on a fishing expedition to out in the remote country. He carried this firearm with him for self-protection, and some 6 or 7 hours later, he was stopped for an OVI traffic stop. Similarly, Mr. Embry, as cited in the transcript, had carried this firearm for two very specific reasons on this particular day in question. The first was his intent to go to the firing range, and I think that's exemplified throughout the transcript in Mr. Embry's testimony to the trial court.
Well, but let me ask you a question. I mean, that might be a legitimate use, but can you use that 24 hours a day, 7 days a week, and anytime you're pulled over, say, well, I'm going to the fire range tomorrow, or I was going to go earlier today and I didn't, I just forgot to take it out. Isn't there some kind of a line there?
You're right, Your Honor, there is, and I would agree with the court in that position. It's not a carte blanche, if you will, open season to carry a firearm. In this particular instance, Mr. Embry had cited to the court during his testimony that in addition, he was a courier. He was effectively an on-call 24-hour-7 courier for his business. He could be called at 11 p.m., 11 a.m., and I believe the testimony is reflective of that. But again, it's not a carte blanche situation where Mr. Embry should be effectively unlicensed but able to carry the firearm 24 hours a day, 7 days a week.
Was he on call at the time he was pulled over?
He was not, and interestingly, in this particular issue, the state relies upon State v. Hendricks as a situation where, and I misspoke before, this was the case that was very analogous to Mr. Embry's, was the State v. Hendricks case where he was stopped some 6 hours later, having a firearm in his possession and removed from what was potentially the reason for his possession of the firearm. In this particular case, though, again, Mr. Embry had testified that he was on call and available 24/7. Again, not a carte blanche way for him to establish him being in possession of his firearm. However, I would note that this particular situation, it was approximately 10:30 p.m. It was established through testimony the firing range was closed, but there was no testimony as to when the actual firing range that he was to attend had closed. Who knows if it was open at 9 o'clock on a Sunday evening, 8 o'clock on a Sunday evening. We don't know if he was an hour removed from when this potential...
But he didn't go there.
I'm sorry?
But he didn't go there.
No, he did not. He did not go
So
there.
what does it matter when it closed?
Well, because I think the state relies upon State v. Hendricks to establish this gap in time, and this gap in time is so large that effectively nullifies the reason or rational purpose for this individual to possess the firearm. In this particular case, I think that gap in time is not established, and that disconnect, as a result, we can't imply or impute facts not in record, and those facts are not established. So it's unclear as to whether or not it was an hour after the range may have closed, 30 minutes, 10 minutes, 6 hours. The court doesn't know. It's not in the record. So I think in the absence of that evidence, it's more indicative of just a lack of evidence.
So the burden's on the state to raise that?
I don't necessarily think the burden is on the state or on my client to raise that. I just think in this particular situation, the trial transcript lacks that evidence.
So if your client says, I have a lawful purpose because I'm transporting this gun to a gun range, well, I'm not on my way and I didn't go, but I'm just trying to understand who has to produce evidence of the time that the gun range opened or closed and why that matters.
Well, I'm not sure that it necessarily the burden is what matters, but I think in just this particular case, that fact or those facts are not in evidence. So for the state to assume, for the trial court to assume those facts, which again are not in existence may have persuaded the court to have a guilty finding ultimately. We're not sure. Again, the facts are not in the evidence. The facts don't support whether or not Mr. Embry was going to attend a range that did close at a later time of the day or an earlier time of the day.
But didn't he testify, he himself testify, he never did go to the gun range, and he simply forgot that he had the weapon in his car, which would, I would argue, make irrelevant what time the gun range closed, even under the case law. Why is it relevant what time it closed if that's his own testimony?
Well, I think it's relevant just because the state, excuse me, had relied upon State v. Hendricks and some of the citations before the brief before the court. And I wanted to point out that I think that's factually disconnected from what we have here with Mr. Embry's case. But I think the bigger issue is that whether or not it was ready at hand. And again, it's established there was a firearm in a box in his front seat, and there was ammunition in the cup holder. And Officer Yeager's testimony and my client's testimony establishes that. We don't skate that fact. We're not trying to end around that fact. But again, I would point out, State v. Davis is relied upon by the state, as well as myself in this brief. There was no magazine. There's no testimony of any magazine.
Explain what difference that makes.
Well, for a firearm to be demonstrated to be ready at hand implies operable. There's case law to support that, right? Well, for it to be
the gun has to be operable and the ammunition has to be close at hand enough that it can be quickly loaded and used.
Right, and there was testimony that this was not a revolver, but a handgun. For a handgun to be operable, there has to be a bullet in the chamber or a magazine with bullets in it and loaded into the firearm. None of those facts exist here. Those facts are not in testimony. So we don't know if the firearm was operable. Right? There's no testimony whether or not there was a bullet in the chamber. There's no testimony that there was a magazine present, or a magazine in the box, or a magazine in the cup holder, or a magazine on the floorboard, or even a magazine with ammunition in it. None of those facts, none of those questions.
There were individual bullets?
There are individual bullets, yes.
And so you're saying it's not ready at hand because he would have, instead of a magazine where you clip it in, he would have to take a bullet and put it in the gun?
Put it in the chamber, yes.
And so that makes it not ready at hand?
Well, I believe that process, along with the fact that there's just a missing magazine. And quite frankly, I don't know enough about guns to tell the court whether or not you could put a bullet in the chamber to get it operable. I'm just not.
Oh, you're saying there needed to be a magazine in order for this gun to even work?
Yes, that's the point.
There was no magazine anywhere?
Correct.
I guess.
Is that in our record, that it required a magazine to be operable?
That's not in the record as well, Your Honor. Again, there's no establishment of whether or not this was actually an
Then how do we know that the gun needed a magazine to work?
Well, because there's testimony that it wasn't a revolver, it's a handgun. So a
Okay.
handgun requires a magazine. And for a magazine to contain the ammunition itself, be loaded in, clipped into the firearm to make it operable and ready at hand. My argument, I'm sorry.
So if I could cut through everything, what you're saying is there's a missing physical piece of the firearm to make it operable. And without that missing piece, it's not operable, therefore
Not ready at hand.
not ready at hand.
He couldn't have loaded it and fired it, is what you're saying?
That's correct.
Okay.
And there's testimony that this was a handgun, not a revolver, the difference being a revolver with a cylinder chamber that can be
Right.
loaded individually and used.
Okay.
That is not the situation here. What we have here is a handgun requiring a magazine to load it in. And again, my ignorance of firearms, I don't possess or have firearms, I don't use firearms, but my ignorance, I don't know if you can simply put a bullet in the chamber to make it operable at that point. I just don't know that. And again, there's not evidence to support that. There's no evidence to support there was a magazine in the car.
But there's no evidence in the record that you have to have a magazine in order for the firearm to be operable either.
Well, it's a handgun. So
We just
I guess
assume,
well, through
that you
17
have
years
to.
of knowledge of doing criminal defense, I
Yeah.
do know that you need a magazine to put in I do know that much.
Okay.
But again, I don't know if simply putting a bullet in the chamber would work. And there's not evidence to support that. And in light of these two arguments that we pose to the court, I would also pose to the court that Senate Bill 215, I think the court is most likely aware of that. It's due to be put into law or effective on June the 13th. Having read 33 pages of legislation 6 or 7 times over the past week, I would just like to put the court on notice that it's our belief through that qualified 2923.111, I believe is the statute, that qualified adult definition would now be applicable to Mr. Embry. Had this incident occurred not September of 2021, but September of 2022, we don't even believe he'd be charged with a crime. I think there's reference again in that legislation that you can go back September 30th of 2011, I believe was the date listed, if drawing from memory, the effective date that you can go back and have these things, these convictions for carrying concealed weapon and improper handling of a firearm expunged. So I think the effective date of June 13th of Senate Bill 215, the legislation speaks through its language in the actual statute that, had this occurred 9, 10, 12 months later with Mr. Embry, he wouldn't be charged with a crime. There was no suspicion of him driving under any suspension, any drugs, nothing of that nature. It was simply a carrying concealed weapon, improper handling of a firearm, were the two charges, the one being dismissed per Rule Criminal 29. So, again, I'm not here to set precedent. I'm not here to tell the court, that this applies to him, but it's our belief that had this occurred a year later, he wouldn't even been charged with a crime. So ultimately, we're asking the court to overturn the conviction. I think it's evident on the very second to last page or last page of the trial transcript that Judge Shanahan makes reference that she believed everybody in the room in terms of credibility. And, it's the credibility rests with the trier of fact. She believed everybody, but ultimately resting with the guilty finding on the carrying concealed weapon. And we're asking the court to overturn that today. Thank you.
Thank you. And you will have 5 minutes left for rebuttal.
Thank you.
Ms. Adams?
Good morning, Your Honors. May it please the Court, Mr. Cello, Mr. Embry. First off, if we could just put to rest the operability issue, that's really not of any significance because there was a stipulation to that prior to trial. It's on page 3 of the transcript, a specific stipulation as to it was a Smith & Wesson 9mm, the model number, its operability, and that the ammunition found sitting next to it was for that firearm.
Hold on 1 minute because I may have a follow-up for you on that.
Okay.
Because he was charged here with the felony level, and the state had to prove, hold on, either that the weapon was loaded, which it wasn't, or that he had ammunition ready at hand.
Correct.
Was the stipulation that there was ammunition ready at hand, or was it that the gun was operable? Because an operable gun...
Well, I can testify that I have fired a 9mm without a magazine in the, just rounding it. So I don't think that if we look at the definition, or the lack of a definition of ready at hand, it allows the court to look at those circumstances that are present before it. I think that...
Well, but I want to push you on this a little bit because it really got me thinking, listening to the argument. The misdemeanor conviction would only require that no person shall knowingly carry or have concealed on the person's person or concealed ready at hand a handgun. So a handgun has to be operable. So that would be the stipulation as to operability, right? Just that it was a handgun. And then to make it a felony, though, then the ammunition has to be ready at hand or the gun has to be loaded.
Well, no, my understanding of operability is that the firearm works, that it can be fired. So the fact that there's no testimony regarding the magazine, I believe that takes that out of the equation, that the stipulation is that it's operable.
Well, it's operable if somebody loads it correctly.
And again, I don't know that that matters in this scenario with the stipulation. The stipulation is that the firearm works and that the ammunition is for that firearm.
They're saying that the only way you can use the ammunition is if there's a magazine, which was missing. It's a piece that was missing, is what they're arguing.
And I don't believe that again with the stipulations, I don't think that that matters, the lack of, and I don't know if the magazine was also in the case, but I think that lack of information there doesn't make the firearm, or that lack of a magazine, even if it wasn't. I think that the testimony, if I recall correctly, with the officer, was that the magazine was not in the firearm, or not in the case. It could have been in the firearm, or I may have that backward.
Okay,
But I don't know that goes to operability.
I mean, even if there were no bullets in the car, the firearm could still be operable.
Correct.
I mean, you have an operable firearm with no bullets. I misunderstood. I thought there was nothing in the record that there was a magazine at all. And so this particular firearm cannot shoot without a magazine.
Right, and again, because of that stipulation, I think that's why that information isn't present in the record. I don't think that was anything that was, given consideration, that because their argument is the ready at hand aspect, that it would have been too complicated, if you will, to chamber around to make it ready at hand under those. So I think that still the case law that's cited is appropriate, and that is the most important guidance that we have in the record here is the fact that those, and there was information regarding, that you have the front seat and then the cup holder. So the firearm is in a gun case in the front seat, and the ammunition is in the cup holder.
Just the individual bullets are in the cup holder.
Correct.
Okay.
Correct. And
to be ready at hand, would you agree that you have to be able to put those bullets into the handgun and make it, and have a bullet shoot out of it?
correct. And oftentimes, even when you have a magazine, say you may have a capacity of, for this particular, I don't know if it's 17, but oftentimes you can then you chamber one, and then that gives you an extra round with the magazine. So that doesn't make that, I mean, we have this occur all the time. So you actually have an extra cartridge already chambered in the round, so it kind of extends the number of cartridges that particular firearm can hold. So I don't think that this is really anything in particular you would have to have that specific testimony regarding the magazine because of this stipulation. Certainly if he were contesting all of that, then all of that information would be relevant. But I think because we have this stipulation that kind of put the court on notice right away that's not an issue in this case. He was more, I guess my argument is that he is saying that the circumstances meant that you couldn't get the gun ready. Not that it was missing a key component or.
Well, that's the way I read his brief is what you just said, that it would have been too difficult to get the bullets in the gun. And then today what I'm hearing is that it doesn't matter if there's bullets because he couldn't have shot that gun anyway because he didn't have a magazine.
Right, and I don't think that information is. And again, my reading of the transcript is this stipulation is important. So I don't want that to be overlooked. And with regard to the second assignment of error, just briefly, again, it's an affirmative defense, so that would have been incumbent upon the defendant to establish those reasons, and he did. I mean, he tried to, he made that argument within the realms of the trial, and the trial court, although she felt that, again, she said everyone was credible, she just didn't think that information rose to the level of providing the affirmative defense. So it was, fairly considered by the trial court, but it just didn't, she didn't believe that it was applicable to him. So of course, unless the court has any further questions, I will submit. Thank you.
Counsel, you'll have 5 minutes remaining.
So just to address a couple of things that Ms. Adams had brought to the court's attention, I would direct the court's attention to page 3 of the trial transcript. Page 3, beginning with line 12, and this is the stipulation that's on record. So we're stipulating that the firearm was present, that it was in a container, actually a gun box, inside the motor vehicle, that the firearm was operable, and finally, sitting next to the firearm was a box of 9mm ammunition for that firearm. So line 16, the firearm was operable. But again, what's absent here? There's no magazine. And I think that is my argument to the court, as Honorable Kraus had pointed out, that is the point, that there's no magazine, there's no evidence of any magazine. So we don't know if the gun was actually fully operable or not. And again, there's no information that there was a bullet in the chamber. I would direct the court's attention to, I believe it's page 10 and 11 of the transcript, where this officer is having a discussion in the trial court that he has found this firearm, and the discussion he's having with Mr. Embry on scene. Again, there's no factual establishment that there has been any magazine present or that there was a bullet in the chamber. You know, the line of questioning with Ms. Adams assumes that these things were present, but it's not in the transcript. And as the court knows, the court speaks through its entries and through the transcript. There's absent missing information here, and that is whether or not there was a bullet in the chamber or whether or not there was a magazine. It doesn't.
Well, but if there, let me play devil's advocate with you.
Sure.
If there wasn't a magazine, then it wouldn't be operable. If it required a magazine, then it wouldn't be operable. But the stipulation was it was operable.
This is correct, and unfortunately, I wasn't trial counsel for the record. I can't indicate, why that strategic decision was made or why that was placed of record. But I think factually speaking, that's just not the case.
Well,
Again,
but what do we do with it, though? If there's a stipulation that it was operable, and if your argument is it wasn't operable because there wasn't a magazine, we can't just regard the stipulation.
Well, I certainly understand the court cannot disregard that, but I'd also point out there was not any reference to whether or not there was a bullet in the chamber, which I think also would render a firearm operable, which then I think would fit under the aspect of what the statute calls for. But again, in this case, that factual information is not present. I'm not sure how the court may handle the operability. I think maybe that's why they pay you the big bucks and your name's on the door, right? But I think that's certainly worth bearing in mind, is because again, these factually missing pieces of information, I think, render it inoperable. And I know there was a stipulation. I'm not sure how the court would deal with that. But we don't think it was operable at that time. We don't think it was ready at hand.
Are you saying a firearm is only defined as operable if it has a bullet in it?
No. I think that is rather extreme circumstance of what I'm trying to point out. I think in this situation, for this firearm, in this instance, to be operable, there had to be a magazine or a bullet in the chamber or both. And in this case, we don't have either. There's no. Again, there's testimony that there's bullets in the cup holder, and it was within, I believe Officer Yeager's testimony was 1.5 or 2 feet, essentially within arm's reach of Mr. Embry. But again, there's no testimony that there's a magazine in the cup holder, there's a magazine in the box, we have a firearm in a box, and we have some ammunition, and the ammunition fits that, and we agree with that. We're not contesting or challenging any of that. But again, I think there's missing factual components which would render it effectively inoperable. Because there's no magazine or no bullet in the chamber. So I don't think it qualifies as being ready at hand. The state had used the one case, I believe it was State v. Jones. They had relied upon a First District Court of Appeals case, which indicates that having a weapon ready at hand means so near as to be conveniently accessible and within immediate physical reach. And again, I don't think we're challenging that aspect of this with Mr. Embry. We think it's within a physical reach. But again, we think that's factually distinguished from this case coming out of the First District Court of Appeals, simply based upon the missing links here in Mr. Embry's case, right? There's no magazine and there's no bullet in the chamber, so how do we know it's even operable? So again, I think you pose a very interesting question, Honorable Judge Myers, about how you deal with the stipulation versus what the facts are itself. I'm not asking to disregard. I really don't have an answer for how to deal with that, because I think it's a conundrum, because it's factually incorrect, in my opinion, based upon my reading of the transcript, the analysis of the case law. So again, we would fall back on the idea that we believe this conviction should be overturned. In light of all of that information, keep in mind, again, Senate Bill 215 is less than 30 days from being effective, right? So, that had this occurred later in time, wouldn't even be a crime. So we'd ask the court to consider that, and we would submit. Thank you.
Thank you. Thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion. That will conclude our arguments this morning for the First District Court of Appeals.
Thank you.
The Court of Appeals, First Appellate District of Ohio is now adjourned.